Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the deep dive. Today we are pulling the handle on, well, a legal jackpot, really. A high-stakes, high-tech patent war fought over how modern casino slot machines actually work.
Yeah, this isn't just about flashing lights and sounds. It's about the guts of the machine, the microchips, and a massive gamble, something like $30 million, hinged on defining technology itself.
We're digging into Wms Gaming Inc. v. International Game Technology, or IGT. It's a key case from the U.S. Court of Appeals for the Federal Circuit, decided back in 1999.
And it's super important because it really draws lines in the sand for what counts as an equivalent invention, especially for software and electronics patents. It tackles that tricky means plus function language.
Right, so our mission today is to unpack how one company, WMS, tried this really clever workaround for a patent. They actually succeeded on one very technical legal point.
But ultimately failed. The change just wasn't different enough in the eyes of the court.
Okay, let's set the scene. So IGT held the patent. WMS was the challenger trying to break in. The case number, for those tracking, is 184 F.3
It started in the district court for the Northern District of Illinois before Judge Holderman Jr. and then went up to the Federal Circuit. The opinion we're looking at was by Judge Schall, with Judge Rader also deciding. Judge Rich also heard it, but sadly passed away before the final decision.
And there were some heavy hitters on the legal teams, right? IGT had Robert Krupke, WMS had Rafael Lupo leading their side.
Definitely big names in patent law. So the core technology here is the Telnaes patent. That's U.S. patent number 4,440,419. IGT didn't invent it originally. They actually acquired it in 1988. But this patent from 1984 introduced the virtual reel.
And the virtual reel was revolutionary, wasn't it? This is where it gets interesting if you're building any kind of software that involves probability or mapping.
Absolutely. Before Telnaes, think about it. If you wanted massive jackpots, like say 1 in a million odds, you needed physically enormous reels with hundreds, maybe thousands of symbols or stops.
Which makes for clunky, unpopular machines. Nobody wants a slot machine the size of a car.
Exactly. Telnaes solved this with electronics. The key idea is non-uniform mapping. It uses standard-sized reels, controlled electronically, but the probability of hitting a symbol isn't tied one-to-one with the physical stops anymore.
How does that work?
Well, the patent talks about assigning a huge range of numbers, a plurality of numbers, way more numbers than there are physical stop positions on the reel.
Okay, so maybe a reel has, say, 20 physical spots you can see.
Right. But Telnaes might assign, 1,000 virtual numbers mapped to those 20 spots. And crucially, the mapping isn't even.
Ah, so that's the trick.
That's the core innovation. You could assign just one of those 1,000 numbers to the big jackpot symbol like the 7, but maybe assign 50 numbers to a common symbol like a cherry.
I see. So the odds of hitting the jackpot plummet, even though the physical reel looks the same, allows for huge payouts without needing huge machines.
Precisely. Game changer. Now, enter Wms Gaming. They saw how dominant this tech was becoming, and they needed their own version. But that Telnaes patent, held by IGT, stood right in their way.
So they developed the WMS Model 400, introduced around 1993, based on their own patent, the Durham patent.
Yeah.
This was their attempt to design around Telnaes.
A very high-stakes attempt, as it turned out.
So what was their big idea? What was the twist WMS introduced that they hoped would make their machine legally distinct?
Well, they essentially flipped the process. The Telnaes patent, as described, works by first selecting a random number, and that number points to a specific reel stop position.
Okay, number first, then position.
Right. The WMS 400 did it differently. It first calculated the outcome, the payoff amount, let's call it Z. It did this using a combination of random numbers, R1 and R2, which map to multipliers.
So it figures out if you won and how much first.
Exactly. Then, using a third random number, R3, it randomly selected a set of physical reel stop positions that would visually represent that predetermined payoff Z.
Okay. So they argued, look, we pick the payout first, then the symbols. Telnaes picks the symbols first. They felt that was a fundamental difference in function.
That was their core argument. But the district court, While they didn't buy it. Not at all.
What did the first court rule?
The district court found that WMS had willfully infringed the Telnaes patent. They also upheld the patent's validity, saying it wasn't obvious. And because of the willful finding...
Meaning they thought WMS knew about the patent and basically copied it anyway, maybe with some superficial changes.
That's the implication of willfulness. And because of that finding, the court trebled the damages, multiplied the base amount by 3, leading to that eye-watering figure of over $30 million awarded to IGT.
$30 million. Okay, no wonder this went to appeal. So when it got to the Federal Circuit, what were the big questions they had to untangle?
It really boiled down to 3 main areas. First, infringement. Did WMS actually infringe, either literally or under the doctrine of equivalence? Second, validity. Was the original Telnaes patent even valid to begin with? Maybe it was obvious based on older tech.
And third,
willfulness and damages. Even if WMS did infringe, was it willful? And was that massive $30 million plus penalty justified?
let's unpack the WMS arguments on appeal. How did they try to convince the Federal Circuit they didn't infringe?
Their main attack was on claim construction, specifically focusing on Claim 1 of the Telnaes patent. They honed in on the phrase, means for assigning.
That sounds like classic patent law argument, means plus function claims.
Exactly. WMS argued the trial court interpreted that means for assigning language too broadly. They said it should be limited only to the specific algorithm shown in the patent's diagrams, specifically Figure 6.
And what about the function itself?
They leaned heavily on the grammar. WMS pointed out that Claim 1 uses singular language, things like assigning numbers to the stop positions and selecting one of said numbers and said selected number, singular.
Okay, see where they're going.
Right. Since their WMS 400 machine used combinations of numbers R1, R2, R3 to determine the outcome and display, they argued it didn't perform the identical function described in the patent claim. Therefore, no literal infringement.
So it's a bit of a semantic argument. Your patent says a number. We use numbers plural, so we're different. Pretty clever.
Very clever. And potentially very effective under the strict rules for literal infringement of means plus function claims.
How did IGT push back against that?
IGT argued that using combinations instead of a single number was, legally speaking, an insubstantial change. They said structurally the WMS machine was equivalent because it still ended up assigning some kind of unique digital tag or identifier to control the real stops based on probabilities. The end result was the same.
And what about the willfulness part? IGT must have pushed hard to keep that $30 million award.
Oh, absolutely. They argued WMS clearly knew about the Telnaes patent. It was famous in the industry. They said WMS failed to design a truly different competitive alternative, couldn't get a license, and basically just went ahead with their slightly modified infringing design. That, IGT argued, screamed willfulness.
Okay, and quickly on validity, WMS said Telnaes was obvious, citing some prior art patents like Cohen and Nonaka.
Yes, but IGT countered effectively there, too. They argued that Cohen and Nonaka were really just about simulating the look of multiple symbols on a mechanical reel, maybe using mirrors or something. They didn't teach the core Telnaes idea,
Which was increasing the underlying numerical range far beyond the physical stops to manipulate the odds.
Exactly. That leap, IGT argued, wasn't obvious from the prior art.
All right, this sets up the Federal Circuit's decision perfectly. It's known for being a bit of a mixed bag, right? What did they ultimately hold?
It was definitely nuanced. They affirmed in part, reversed in part, vacated in part, and remanded. A bit of everything.
Let's break it down. What happened with literal infringement?
Reversed. The Federal Circuit agreed with WMS on that point. They found WMS did not literally infringe. That's a win for WMS.
Okay. What about infringement under the doctrine of equivalence?
Affirmed. The court found WMS did infringe under the doctrine of equivalence. That's a loss for WMS and a big win for IGT.
And patent validity. Was Telnaes valid?
Affirmed. The Federal Circuit agreed with the lower court that the Telnaes patent was not invalid for obviousness. Another loss for WMS.
Okay, so IGT wins on validity and on infringement via equivalence. Yeah. What about the big money, the willful infringement finding?
That was vacated and remanded, basically sent back to the lower court for another look. So a partial win for WMS there, potentially saving them from the triple damages.
So a real split decision, but the bottom line is WMS was still found to be an infringer, just not literally. Let's get into the why. Why did the court reverse on literal infringement? That seems like WMS's biggest victory here.
It all hinged on the interpretation of 35 U.S.C. Section 112, paragraph 6, that means plus function statute we mentioned.
Right, the rule for claiming a function without detailing every bit of structure.
Yes, but it comes with a strict test for literal infringement. The court clarified that the structure corresponding to the means for assigning function was indeed limited to the specific algorithm disclosed in the Telnaes patent, the one using a single number selection process.
And the function itself.
Critically, the court agreed with WMS that the claimed function, based on that singular language, one of said numbers, said selected number, was explicitly limited to assigning and selecting single numbers.
So, because the WMS 400 used combinations of numbers.
It failed the test. For literal infringement under 112, paragraph 6, the accused device must perform the identical function. Since WMS's function involved combinations, it wasn't identical. That seemingly small difference in process was fatal to IGT's literal infringement claim.
That's fascinating. WMS threaded the needle perfectly on the language of the law there. But then, how did IGT immediately win on the doctrine of equivalence? If the function wasn't identical, how could it be equivalent?
That's the power, and some would say the ambiguity of the doctrine of equivalence. It's a broader, more equitable test, it asks. Does the accused device perform substantially the same function, in substantially the same way, to achieve substantially the same result? Or, framed differently, are the differences insubstantial?
And the court found the differences here were insubstantial.
Yes. They affirmed the lower court's finding on this. They reasoned that the difference between using a single number versus using a combination of numbers to ultimately determine a real stop position was, in the grand scheme of the invention, insubstantial.
Even though WMS calculated the payout, Z first, they argued that changed the way it worked.
The court acknowledged WMS performed an extra step, calculating Z first, but they concluded this extra step didn't change the basic character of the device. WMS still ended up assigning numbers, or tags, to stop positions to manipulate odds electronically, achieving the same core result as Telnaes using a very similar underlying principle.
So the functional difference wasn't substantial enough. It looked like a clever workaround, but didn't change the essence of what the machine did.
Precisely. Since the differences were deemed insubstantial, WMS infringed under the doctrine of equivalence. It caught the design around that literal infringement missed.
Okay, let's touch on validity again. Why was the court so convinced Telnaes wasn't obvious, despite WMS's arguments about prior art?
They relied heavily on the obviousness framework from Graham v. John Deere Co., especially the secondary considerations or objective evidence of non-obviousness.
What kind of evidence?
Things like the huge commercial success of virtual real technology. It basically took over the entire slot machine industry. Also, evidence of a long-felt need for such a solution, and critically, the fact that major competitors like Bally and Universal had taken licenses and paid IGT millions in royalties for the Telnaes patent.
If your competitors are paying you millions for it, it's hard to argue it was obvious all along.
Exactly. That real-world evidence strongly suggested the invention was truly non-obvious at the time it was made. It really bolstered IGT's case and helped overcome the arguments based on the Cohen and Nonaka patents.
Makes sense. Now back to the damages. Why vacate the willful infringement finding? If WMS infringed under equivalence, why weren't they willful?
The key was the reversal on literal infringement. The original finding of willfulness by the district court seemed heavily tied to the idea that WMS had literally copied. The Federal Circuit emphasized something important. Patent law actually encourages competition and designing around existing patents.
So trying to design around isn't automatically bad faith.
Not necessarily. Since WMS was successful in avoiding literal infringement, they found a technically distinct way. Even if it wasn't substantial enough for equivalence, their actions had to be reevaluated. Was their attempt a legitimate, albeit ultimately unsuccessful, design-around effort, or was it still egregious copying?
So the case went back down for the lower court to reconsider if WMS's infringement, now understood as infringement only by equivalence, still warranted the punitive trebling of damages.
Correct. The base damages, around $10.7 million for the infringement itself, were affirmed. But the extra $20 million penalty was put back on the table for reconsideration based on this more nuanced view of WMS's conduct.
That distinction seems crucial for innovation. You don't want to punish people too harshly just for trying to find a non-infringing alternative.
Exactly. It protects the incentive to innovate around existing patents.
Were there any dissenting or concurring opinions filed Any judges disagree with this complex outcome?
No, there wasn't a separate dissent or concurrence published. As mentioned, Judge Rich heard the argument but passed before the opinion issued, so it was decided by Judges Rader and Shao.
Okay. So, looking back now, what's the big legal significance of this WMS v. IGT decision? Why do patent lawyers still talk about it?
It's hugely significant, especially for patents in software, electronics, anything using that means plus function claim language under 112 paragraph 6. It really cemented two key principles.
What's the first one?
First, it set a very high bar for literal infringement of those claims. You need identical function. Even a subtle difference, like WMS using combinations versus single numbers, can be enough to escape literal infringement. That gives potential innovators some breathing room.
But there's a flip side.
The flip side is the second principle. It powerfully reinforced the doctrine of equivalence as the patent holder's crucial safety net. It showed that even if you cleverly avoid the identical function test, if your change is ultimately deemed insubstantial, you can still be found liable for infringement. IGT still won the war, even losing the literal infringement battle.
So it balances protecting the patent holder against overly clever copies, while also defining a clear path, albeit narrow, for avoiding literal infringement.
Yes, and it also stands as a great example of how powerful objective evidence, commercial success, licensing by competitors can be in defending a patent's validity against obviousness challenges.
Okay, that brings us to the end. If you had to boil this whole complex case down to one single most important takeaway for someone listening, what would it be?
The key takeaway, I think, is the critical distinction the law makes between technical difference and legal difference, particularly the concept of substantiality. WMS achieved a clear technical functional difference. Calculating payout first using combinations of numbers. That won them the literal infringement argument.
But it wasn't enough.
It wasn't enough because, in the eyes of the court applying the doctrine of equivalence, that difference was insubstantial. It didn't fundamentally alter the way the invention worked or the result it achieved in the context of the patent's core contribution. The takeaway is that merely adding a step or changing the order of operations might not save you if the core principle remains the same. Avoiding the doctrine of equivalence requires a truly substantial departure.
So WMS walked a legal tightrope. They avoided the harshest finding of literal infringement and likely the triple damages because of it, but they couldn't escape infringement altogether. IGT still got paid, validating their patent strength.
That's right. And it leaves us with a final thought, maybe a provocative one for innovators listening. The law says you're encouraged to design around patents. WMS tried. They succeeded technically, but failed legally on the substantiality test. So the lingering question is, how different does your invention really have to be? How much functional change, how much complexity is needed to cross that fuzzy line from an infringing equivalent to a truly new, non-infringing design?
And as this multi-million-dollar case shows, the answer isn't always clear-cut and can depend heavily on how a court weighs those differences.
Exactly. That insubstantiality test remains a critical and sometimes unpredictable battleground in patent law.